I welcome you all on this bright Sunday, the 2016. So let me start with the introduction, which is none other than never give up. Yes, the gold medal against the Olympian medals on the Olympic final. Today, we are here for this webinar. Next is very vibrant personality who do not need any but will start with this introduction. So already started the 4 5 hours. Member of Secretarial Board of the Institute of Communications of India. In the past, he also has been a member of the board and several boards of committees of master class for directors. Also, corporate governance and public applause from myself.
Thanks, Gaurav, for the nice words. A very good morning to all of you. I have great pleasure in making this presentation on Companies Amendment Bill 2016. First, a brief background. Friends, as you know, Companies Act 2013 was enacted to rewrite the 1956 law. It was said to be epochal. However, when the 2013 Act was implemented, companies started to understand the finer nuances and various flaws in the law. Following vociferous representations from industry chambers, professional institutes, government departments, and others, Companies Amendment Act 2015 was passed, which gave some immediate relief to companies. During the consideration of the Companies Amendment Bill 2015 in the Rajya Sabha, views were expressed that more amendments would be required. Accordingly, a Companies Law Committee was constituted, which had representatives from the industry, the professional institutes of company secretaries, chartered accountants, cost accountants, etc., and certain other categories. The committee invited suggestions from various stakeholders and held consultations with them. The committee submitted its report to the government on 1st February 2016, which was put in public domain for comments. Based on the report and comments received from stakeholders and government departments, it was decided to amend the Companies Act 2013. So accordingly, this Companies Amendment Bill 2016 was placed in the Lok Sabha. The proposed changes are broadly aimed at addressing difficulties in implementation owing to stringency of compliance requirements, facilitating ease of doing business in order to promote growth with employment, harmonization with accounting standards, SEBI Act, RBI Act, and the regulations under these acts, rectifying omissions and inconsistencies in the Act, and carrying out amendments in the provisions relating to qualifications and selection of members of NCLT and NCLAT in accordance with the directions of the Supreme Court. The bill has been referred to the Parliamentary Standing Committee on Finance, which was to submit its report within 3 months. Today, I'll discuss the important changes proposed in the amendment bill and their implications. So, friends, let me first start with the proposed deletions in the bill. What are the sections which are proposed to be deleted? Now, the first welcome deletion is the requirement with regard to ratification of annual ratification for appointment of auditors, which is contained in proviso to section 139 subsection 1. Now, friends, it was very strange that once the shareholders have approved the appointment of the auditors for 5 years or 6 years at a time, they were required to place annually the same thing for ratification by members. Ratification in normal legal parlance is understood to be ex post facto approval. Now, when something is approved for a period of 5 years or 6 years, where is the question of annual ratification? So, following representations and understanding that such a provision doesn't make sense, the new bill proposes to remove this unnecessary irritant clause. Another important provision which is being deleted is the one under section 186 subsection 1, which lays down that you cannot make investments through more than 2 layers of subsidiaries. Now, purportedly the purpose was to ensure that at the grassroots level, the final company's funds are properly traceable. But practically, it led to a lot of problems whenever a company wants to make a structure, especially through countries outside the country, which may be necessary from the taxation point of view and certain other considerations. Understanding the problems faced by the companies, it has been now decided to remove this particular provision, and which is a welcome one. Next deletion is that of section 194, which placed restrictions on forward dealings in securities by company or its KMPs, etc. Now, as we all know, SEBI has separate provisions for forward dealings by companies, KMPs, etc. There was no point in putting section 194 on the statute book, because so far as listed companies are concerned, where this section is relevant, they are already covered under the listing of agreement or LODR regulations. So the wiser sense is prevailing, and section 194 is planned to be deleted. On a similar footing stands section 195, which put prohibition on insider trading of securities. Here again, since unlisted companies, there is no question of insider trading because there is no market for the securities. This section was not relevant. And now the government is proposing to delete this particular section, section 195 also. Another deletion is section 93, which talks of return of changes in promoters or top 10 shareholders stake. As per Rule 13, for MGT 10 is to be filed within 15 days of 2% or more change, whether increase or decrease in such holdings. Now, again, this is not serving much purpose since returns of changes in shareholding pattern are already forwarded to the stock exchanges by companies. So, wiser sense again has prevailed, and section 93 is proposed to be deleted. Definition of interested director under section 2, subsection 49. Now, this particular definition of section 2, subsection 49 is there on the statute book, but it is not being referred to or used in any substantive provision. Section 184, which talks of contracts with parties in which directors are interested, uses a separate definition to define such contracts. As such, the only thing section 2, subsection 49 created was confusion. Realizing this and following various protests, it is proposed to delete section 2, subsection 49. That is the definition of interest director. In the memorandum of association, there is a very important change. Now, under section 4, subsection 1c, a company has an option either to lay down the specific objects for which the company will function, which is the position right now also, or alternatively, it can put an omnibus clause that the company may engage in any lawful act or activity or business which is permitted by the law. As a result, if a company chooses this particular option, it need not change its objects every time it wants to pursue new activities. So, once the amendment bill becomes law, this flexibility will be given to the companies to insert such a clause whereby they can pursue any legal or lawfully permitted object. Then, under section 4, subsection 5, for name change or new name approval, currently ROC reserves the name for 60 days from the date of application. Now, the name will be reserved for 20 days from the date of approval. So, this is shortening the time, and in view of electronic mode of working, it tries to shorten the period and also wants that the companies make their applications quickly. In the annual return, under section 92, subsection 1, subsection C, particulars of indebtedness are to be given. Now, this doesn't serve much purpose and it is proposed to be omitted. Section 92, subsection 1J requires that names, addresses, and other details of FIIs should be given. Now, the section will say details as may be prescribed in respect of shares held by or on behalf of FIIs should be given in the annual return. So, only the really desirable and necessary details will be asked in the form of the annual return. Now, currently, section 92, subsection 3 requires that extract of annual return should be included in the director's report. The new provision says a copy of the annual return should be placed on the website of the company and the web link of such annual return should be disclosed in the project. So, it's a welcome relief. A detailed extract of the annual return would not be required to be placed or incorporated in the director's report. Only the web link will have to be disclosed. AGM of an unlisted company, as per the bill, may be held at any place in India if consent is given in writing or by electronic mode by all the members in advance. This is a new proviso under section 96 subsection 2, which is a welcome relief for small companies who will be able to have the annual general meeting at any place in India as long as all of the members want to see it. Next is extraordinary general meeting of a company, which is other than a wholly owned subsidiary of a company incorporated outside India, can be held at a place within India. This is as per section shall be held at a place within India. This is as per section 100 new provision, which is basically clarificatory, but it says that an extraordinary meeting of the company other than that of wholly owned subsidiary of a company incorporated outside India shall be held at a place within India. Currently, the position is that due to lack of any specific restrictions, EGM could be held anywhere in the world. With this, since it is now put on the statute book, only in case of a company which is not a wholly owned subsidiary of a company incorporated outside India, the EGM should be held at a place within India. So in case of a company which is wholly owned subsidiary of a company incorporated outside India, the EGM can still be held overseas. Now, with regard to general meeting at a shorter notice, section 101 proviso has been put, which says that general meeting at a shorter notice will be possible if consent in writing or by electronic mode is accorded thereto in case of AGM by not less than 95% of the members entitled to vote, and in any other general meetings case by members of the company holding, if the company has a share capital not less than 95% of such part of the paid up capital of the company as gives a right to vote, and where the company has no share capital not less than 95% of the voting power. So basically, there will be separate provisions for AGM and EGM. For AGM, 95% of the members are required to consent, and in other cases, in EGM, members holding 95% of the voting power are required. Now, with regard to CSR, under section 135, subsection 1, the term any financial year is proposed to be replaced by the term immediately preceding financial year. Now, this is section 135, subsection 1, which talked of during any financial year. And as per circular 21 of 2014, the government said that any financial year would mean any of the preceding 3 financial years. Now, to make it clearer, the proposed section says during the immediately preceding financial year, to put at rest any doubts of interpretation, because multifarious interpretations were being made. Now, with regard to constitution of CSR committee under section 149, subsection 4, and the number of independent directors it has to have, the question was where for a company independent directors are not required under section 149, subsection 4, what should they do? Now, the amendment proposes to add a proviso that where a company is not required to appoint an independent director under section 149 subsection 4, it can have in its CSR committee 2 or more directors. So that means it need not have independent directors in its CSR committee because in the first place it is not required to have independent directors. A very interesting and important change is being made. Earlier explanation to section 135.5 defined the term average net profit. Now it defines the term net profit. The implication is that earlier 135 subsection 1 talked of net profits and 135 subsection 5 talked of average net profits. Average net profits was defined earlier as profits calculated as per section 198. Now the problem arose when the companies were to consider net profits for the purpose of applicability of section 135 and for constitution of CSR committee, they were to be considering the net profits, which is profit as per the balance sheet. Whereas for the purpose of spending 2% of the net profits, which is the average net profits, they had to consider under section 198. Many companies were there in whose case the calculation of net profit and the average net profit under section 198 were entirely different. So we had many companies to whom section is applicable, CSR committee needs to be constituted, but they do not have average net profits. So they don't have to contribute anything because of calculation of average net profits under section 198. Now it says the explanation has been revised to say for the purpose of this section, that is the entire section, net profit shall not include such sums as we prescribed and shall be calculated in accordance with the provision of section 198. So that means both for section 135 subsection 1 and for 135 subsection 5, the net profits will be calculated as per section 198. That means for the determining the threshold of applicability in case of net profits of 5 crores or more, you have to see the profits under section 198 and not the book profits as per the balance sheet. So this will remove the cases where the company has to constitute the committee but not to contribute towards CSR. With regard to directors, one of the proposed changes under section 160 subsection 1 new proviso is that at the time of proposing candidature for directorship, in case of an independent director or in case of a director recommended by nomination and remuneration committee, the deposit of rupees 1 lakh need not be made. This is making life easier for the companies who unnecessarily had to make arrangements to deposit the sum of 1 lakh rupees, etc., which was required as per section 160 subsection 1. So as long as the person is independent director or a director recommended by nomination and remuneration committee, the deposit need not be made. Now, under section 161 subsection 2, a person cannot be appointed alternate director in a company if he is holding directorship in the same company. This is just clarificatory. Earlier it was, if a person is holding alternate directorship in the company, he cannot be appointed alternate director for any other company. Now the law says, if a person is holding alternate directorship in the company or holding directorship in the company, he cannot be alternate director for anybody. That means if a person is already a director of the company, he cannot accept alternate directorship for another director. That is, there can't be two directorships at the same time. If a person is appointed as a director of a company which is in default in clause A or B, he shall not incur the disqualification for a period of 6 months from his appointment. This is as per section 164, subsection 2, new provision, which says, provided that where a person is appointed as a director of a company which is in default in clause A or B, he shall not incur the disqualification for a period of 6 months from the date of his appointment. A or B are the disqualifications for a company which has not filed financial statements or annual returns for a continuous period of 3 years, or which has failed to repay the deposits or interest thereon, or to redeem debentures on the due date, etc. And such failure continues for a period of 1 year. Earlier, the position was a person who is or has been a director of such company, which is hit by these disqualifications under A or B, shall be eligible to be reappointed as a director of that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. Now it says, he shall not incur this disqualification for a period of 6 months from the date of his appointment. This is with a view to giving reasonable time to the new person to set the house in order. Now, disqualifications in clause B, E, and G of subsection 1 shall continue to apply even if appeal or petition has been filed against the order of conviction or disqualification. This is under section 164, subsection 3 provides. That means even if appeal has been filed against the order of conviction or disqualification, even then the disqualification will prevail. Under new explanation 2 to section 165, when you reckon the limit of directorship of 20 companies, the maximum limit of directorship, the directorship in a dormant company shall not be included. That means if a person is already a director in 20 companies, he can still be a director in a dormant company. Where a director incurs disqualification under section 164(2), the office of the director shall become vacant in all the companies other than the company which is in default under that subsection. This has been put under section 167, subsection 1A by way of a new provision. Now, this is very important. Earlier section 167, subsection 1 states that the moment a person incurs any disqualification specified in section 164, his office of director becomes vacant. Now with the result that if a company defaults in filing the balance sheet, annual return, or repayment of deposits, etc., all the directors are hit by section 164, and consequently under section 167, subsection 1, the office of each of the directors becomes vacant, which unnecessarily creates a problem, creating a vacuum in the company. Now it says that in such a case, the office of the director shall become vacant in all the companies other than the company which is in default. So that means in a company which is actually in default, the directors will not vacate office, but in all other companies, they will vacate office. This is a very important and interesting change. Another unnecessary provision which had been put under section 168, 1, which says that At the time of resignation, a director shall also forward a copy of his resignation to ROC, giving the detailed reasons. Now, this is being substituted with the word may. It is not now mandatory on a director to furnish a copy of his resignation along with the detailed reasons. He may if he wants to. That is, if there is a genuine ground for him to bring to the notice of ROC, he can, but otherwise he is not under obligation. Board meeting through video conference. Where physical mode and in a meeting physical quorum is present, any other director may participate through video conference as well. This has been provided under section 173 subsection 2, so that as long as a physical quorum is there, other directors too can participate irrespective of the fact that the meeting is discussing items which have been prescribed by the government to be discussed in a physical meeting. Items like consideration of annual financial statements, etc., can be considered in a physical meeting, but the directors in such a meeting, as long as physical quorum is there in the meeting, other directors can always participate now through electronic means. Now, with regard to managerial remuneration, there are several changes. A few sections have been changed. Wherever central government approval was required, the reference to central government approval has been deleted. For example, under section 197 subsection 1, in the proviso, provided that the company general meeting may, with the approval of the central government, authorize payment of remuneration exceeding 11% of the net profits of the company, subject to provisions of Schedule 5. Now, with the approval of the central government, words have been omitted. That means, if you want to go for a managerial remuneration in aggregate exceeding 11%, you need not go to the central government, but you can do with the approval of the general meeting. Similarly, for individual remuneration exceeding 5% to one managing director, or 10% to more than one managing director, or 1% of net profits to non-full-time directors, or 3% of net profits to non-full-time directors, in a case where there is no managing or full-time director, etc., or manager, etc. In all these cases, the respective limits can now be increased by the company by a special resolution in general meeting without referring to the central government for approval. So basically now the powers of the central government are being delegated to the company general meeting, and they can decide the remuneration payment. In case of defaults, NOC from banks, lenders, creditors required before excess remuneration is paid. So in a case excess remuneration has been paid and it is to be waived, members can appeal resolution prior approval of bank, financial institution, etc. will be required where any term loan is subsisting. So as long as these term loans, etc., are subsisting, the prior approval of bank or financial institution has to be taken. And after that, the waiver can be done as long as special resolution is passed. Similarly, under section 197(11), where the remuneration is to be increased in case of no profits or inadequate profits, central government approval is not required. A new requirement, section 197 subsection 16, auditors will have to state whether the remuneration paid to directors is as per section 197 and will have to give the details which are prescribed. This is to ensure a double check on the computation and payment of remuneration and to make the auditors responsible for reporting on the remuneration paid. Section 197 subsection 17 is a clarificatory section which says that all applications which are pending with the central government for approval of managerial remuneration, whether exceeding 5% or 10% or in the aggregate 11% or whatever, all will abate and will be referred back to the companies. So the companies will now be required, once the bill becomes law, all such applications will abate and the company will be required within 1 year of such commencement of the Amendment Act to obtain the approval of the shareholders in accordance with the provisions. Loans to directors. Section 185 has been entirely recast. Now, under 185, subsection 1, loans cannot be given to any director of a company or of a company which is its holding company or any partner or relative of any such partner or any firm in which any such director or relative is a partner. The next section 185 subsection 2 gives an exception and says in what cases loans can be given and under what circumstances. It says loans can be given to any person in whom any of the director of the company is interested. Now, these are the categories of persons in whom any director is considered interested. This is any private company of which any such director is a director or member, any body corporate at a general meeting of which not less than 25% of the total voting power may be exercised or controlled by such director or by 2 or more such directors together, or any body corporate, the board of directors, managing director or manager whereof is accustomed to act in accordance with the directions or instructions of the board or of any director or directors of the lending company. If, now these are the conditions, special resolution is passed by the company in general meeting, full disclosures are given in the explanatory statement, and the loans are utilized by the borrowing company for its principal business. Now, if these conditions are satisfied, loans can be given to these people specified in section 185, subsection 2. Audit committee, under section 177, subsection 1, earlier audit committee is mandatory for every listed company. Now it is clarified that audit committee is mandatory for every listed public company. This is to avoid some situations where even a private company could have listed its debt securities, etc. An important change under section 177, subsection 4, subpoint 4, new proviso says, in case of a transaction other than transactions referred to in section 188, and where the audit committee doesn't approve the transaction, public. Under section 178 subsection 2, nomination and recommendation committee need not carry out performance evaluation, but will specify the manner and agency for evaluation. It shall review the implementation and compliance. Now, this is clarificatory and attempts to remove the confusion, because apart from nomination and recommendation committee under section 178, there are a couple of other places where there was a thought of performance evaluation. Now, at least with regard to nomination and recommendation committee, it has been removed. So instead of the words, the committee will carry out evaluation of every director's performance, it says the committee will specify the manner for effective evaluation of performance of the board, committees, and individual directors, and review its implementation and compliance. Next is under section 178, section 4, C proviso. The remuneration policy shall be placed on the website of the company, if any, and the salient features of the policy and changes therein, if any, along with the web address of the policy, shall be disclosed in the board's report. Currently, the requirement is that such policy shall be disclosed in the board's report, making it an unnecessary and prolonged disclosure in the board's report. Now it is being removed. As long as you place the policy on the website and the salient features of the policy and changes along with the web address, they need to be given in the director's report. So this will make things much easier while drafting the director's report. Acceptance of deposits. Under section 73 subsection 2C, presently 15% of deposits maturing during a financial year and the financial year next following are to be kept in the bank. As per the proposed amendment, on or before 30th day of April each year, the company has to deposit not less than 20% of the deposits maturing during the following financial year in a bank. So earlier it was 15%, now it is 20%, but earlier it was for the deposits maturing during the current financial year and the financial year next. Now is 20% of the deposits maturing during the financial year, during the following financial year. With regard to section 73 2B, which talked of deposit insurance to be obtained, this section is proposed to be deleted because it was proving burdensome and not practicable for companies in the absence of deposit insurance products. A default in repayment of deposits would be ignored if it has been made good 5 years back. Now, under section 73, subsection 2E, earlier the position was, if at any time in the history of the company there has been a default in repayment of deposits, the company cannot raise further deposits. Now, the amendment says that if in the past there has been a default which has been made good and 5 years have lapsed from the time it has been made good, you can raise fresh deposits. So, only the period of 5 years is there to bar the company to raise fresh deposits. Later on, the company can raise the deposits. In private placement, some changes have been made. The return of allotment has to be filed within 15 days, which is presently 30 days. It has been reduced to 15 days. Money received not to be used till return of allotment filed. That means till the return of allotment is actually filed to the registrar of company, irrespective of the date of allotment, you will not be able to use the money. So you need to file the return of allotment quickly, as early as possible after the allotment, so that you can utilize the monies. The offer should not include the right to renounce. The offer letter should not include the right to renounce. Some miscellaneous changes. A general meeting special resolution under section 180 subsection C would be required if borrowings would exceed the aggregate of paid up capital, free reserves, and securities premium. Presently, only paid up capital and free reserves are recorded. So now, in addition to paid up capital and free reserves, securities premium would also be considered while working the threshold limit beyond which general meeting special resolution is required. Exemption under section 184 subsection 5b would now cover transactions with bodies corporate. Now, this particular section is a gateway as long as the transactions are with companies wherein the directors of the company together hold not more than 2% of the share capital. The entire section is not applicable. But the word used is between two companies. Now it is being expanded to use the term bodies corporate. That means as long as transactions are there between the company and another body corporate, and the directors of the company collectively hold not more than 2% in the other body corporate, the section would not be applicable. Under section 186 subsection 2, the proposed explanation states that person does not include any individual in employment of the company. Now, under section 186, for loans, investments, etc., the term any person was used, which included employees of the company. As a result, any loan to employees was covered under the rigors of the section, including monitoring the limits and recording the transaction in the register. Now, as a relief to companies, the term person will not include employees. Accordingly, loans to employees will fall outside the purview of section 186. Liability of members where the number is reduced below 7 are 2. This is under section 3A, which is a new section. Under 1956 Act, section 45 had a similar provision that where the members of a company are reduced below 7 in case of public company or below 2 in case of a private company, and the company carries on business with the knowledge of the people for more than 6 months, then the members are personally liable. This section was not there in the Companies Act 2013, but now on a par with section 45 of 1956 Act, it is now proposed to be brought into the Companies Act 2013 by way of section 3A. Under section 441, now offences punishable with fine or imprisonment could also be compounded. Non-compoundable offences now would be an offence punishable with imprisonment only, or punishable with imprisonment and also with fine. Earlier, if you recall, in 1956 Act, wherever an offence was punishable with fine only, or with fine or imprisonment, it could be compounded. 2013 Act changed this, and wherever imprisonment was there, whether compulsory or optional, those offences were put in non-compoundable category. Now, the status quo ante is proposed to be restored. As a result, any offence punishable with fine only or with fine or imprisonment would be eligible for compounding. Under a new proviso to section 136, subsection 1, financial statements may be sent less than 21 days before the date of the meeting if it is so agreed by 95% of the members entitled to vote at the meeting. So this is a new and welcome provision and helpful for small companies where the number of members is low and they are closely held companies. So if they want, with 95% consent, the financial statements can be circulated at less than less than 21 days period. Now, threshold limit for fraud has been fixed at rupees 10 lakhs or 1% of the turnover, whichever is low. And for lesser than these limits, lower fine and imprisonment have been indicated. As you know, friends, under section 447, currently there are no threshold limits for fraud. Even a fraud of 10 rupees by an employee in a conveyance bill is a fraud, which is punishable, etc. There was a demand for putting suitable threshold limits. While they have put the threshold limits, I think the wording still is not very happy. They have probably considered a large company with 100 crore turnover, where 1% of the turnover would be 1 crore. So they say the threshold of 10 lakhs or 1% of turnover, whichever is less. They have made this the threshold. But let's think of a company which is in the project mode and which has zero turnover. So 1% of zero is zero. So the threshold limit is 10 lakh rupees or zero, which is zero. So again, such a company is subject to the same rigors as before this amendment. That is, even a 10 rupees so-called fraud in the conveyance bill of an employee or any other sort of fraud or wrong invoicing or whatever will be held or possibly held to be a fraud, attracting section 447, attracting imprisonment and all the consequences. So while the intention has been good to amend the section, the wordings have not been happy and probably they will have to revisit it. In the definition of related party, one more addition under under section 2, subsection 76 by way of clause 8, an investing company or the venture of a company. So these are also being put in the category of related party. Restriction in second proviso to section 188 subsection 1 shall not apply to a company in which 90% or more of members in number or relatives of promoters are related parties. So that means if under section 188(1), where a special resolution is required for transactions with related parties above a threshold limit, where the current provision is that the related parties cannot vote, it says restriction in second proviso shall not apply to a company where 90% or more members in number or relatives of promoters are related parties. That is, in case of closely held companies or small companies or private companies, there will be sufficient flexibility that they'll not be stopped from voting on the resolutions. In section 141, subsection 3, there is a correction in language. Subsection 1, I. There is a correction in language. If you look at that section earlier or as at present, if an audit firm has an associate or a subsidiary, etc., who does any sort of consulting business, renders consulting services to any other company, it is not eligible to do audit for. So this was due to very clear wording of the existing section. Now this is being changed to restrict the audit firm from giving the consultancy services only to the company or its subsidiary. The definition of net worth under section 2 subsection 57 is being changed to include debit or credit balance of profit and loss. It is just to make things clear and in consonance with the accounting standards. Definition of small company under section 2 subsection 85 is proposed to be amended. Presently, the paid up capital maximum of rupees 50 lakhs or higher prescribed amount up to rupees 5 crores is there. Now, the higher prescribed amount can be up to rupees 10 crores. It is just an enabling provision that the government now will be able to prescribe up to 10 crores instead of 5 crores. And similarly, for the turnover ceiling of existing rupees 20 crores, the government can prescribe a higher ceiling up to rupees 100 crores. So these are only changes which have been made to empower the government to prescribe higher limits. For sweat equity shares, under section 54, subsection 1C, the condition of 1 year of completion are being deleted. That means sweat equity shares now can be issued by a company immediately without waiting for 1 year. Under section 134, subsection 1, a CEO has now to sign financial statement even when he is not a director. So earlier, a CEO, if he were not on the board of directors of the company, was not required. But now, CEO is required to sign the balance sheet mandatorily, irrespective of whether he is a director or not. Definition of subsidiary, an important change under section 2, subsection 87. 2013 Act brought a different definition of subsidiary company. 1956 Act talked of control of more than half in nominal value of equity shares. 2013 Act talked of more than half of the entire share capital, taking within its sweep preference share capital also. Now this was giving rise to a lot of problems. Ultimately, realizing the mistake, the government has decided to change the definition of subsidiary company to state that the criterion will be exercise or control of more than half of total voting power. Now, this will be more or less on similar lines as it was in 1956. Thank you, friends. That's it. I hope I was able to explain the important sections. If you have any questions, we'll welcome them.
Thank you, Lalit sir, for giving the technicalities of the company's secretarial. It was a nice session and a great thing. So now we will wait for the question and answers for the people if they have given any question. So you can ask your questions directly by the URL of YouTube. Below it, please comment. We are waiting for your questions and we will answer that. We will try to answer through Lalit sir. So Lalit sir, please.
Thanks for that.
Thank you. Thank you. We are winding up.
Okay, friends, thanks again. Thank you.